Hello and welcome to this MBL intermediate session on making applications to remove executors, what practitioners need to know. The aim of the session is to give you a complete toolkit that you can refer to as practitioners whenever you're asked to advise on Section 50 applications, whether for a claimant or if somebody is defending. It will help you to consider key factors such as persuading parties to consent, and it'll help you consider making applications for costs and where they should fall. Throughout, I have interchangeably adopted the term personal representative and executors. Forgive me if that's confusing, but sometimes it's a mixture of both. I've also adopted a football theme for the talk simply because removing executors tends to be very much like manning a football match and refereeing it to conclusion. So I am Veronica Howley. I am a solicitor. I've been in practice around 25 years in general litigation, and for the last 10 years of that or so, I've dealt exclusively with contentious trusts and probate. And a lot of my work involves helping executors, so I'm familiar with the process and I want to help you get familiar and comfortable with it as well. So, as a preliminary matter, this course deals almost exclusively with the grounds and procedure for removal of executors under Section 50 of the Administration of Justice Act 1985. There is some overlap in the case law that applies to the judicial removal of trustees, but those cases have the same grounds for removal, same jurisdiction for the court to consider, so they are sauce for the goose as well as the gander in these cases. I'm not going to consider the removal of administrators of estates under Section 16 of the Senior Courts Act in any detail. That's a completely separate form of application, and although there's significant overlap between the two of them, it really is a subject for a different webinar.